I'm Mike Hackard with Hackard Law. I handled my first will challenge over 45 years ago. Now, much has changed in the world of law. That said, will challenges, unlike trust disputes, are similar to what they were back then. Wills can present unexpected windfalls or the transfer of treasured possessions. They can bring families together or they can split families apart. Getting disinherited can feel like abandonment or expulsion from the family. It hurts. Heirs want to look behind it. So let's talk about the bases for California will challenges. Lack of formalities. In California, oral wills that are not in writing are invalid. A will can be typed or it can be handwritten. The maker of the will, called the testator, does not need to type the will himself. The testator must be at least 18 years old. Holographic or handwritten wills are also accepted in California. To qualify as a holographic will, it must be entirely written by the testator and signed by the testator. Holographic wills do not require witnesses. California also has something that is called a statutory will, and it's a fill-in-the-blank document. It must be filled in exactly as it's written. It must be dated and signed. It must also be witnessed and signed by two disinterested witnesses. A witness is disinterested when they don't receive any financial benefit from the will. It's not necessary to have a notary to make a valid will. Lack of mental capacity. The maker of a valid California will must have sufficient mental capacity to understand the act of making the will, the situation of their property, and relation with their own descendants. Lack of knowledge and approval. Sometimes people sign documents without knowing that it's a will that they're signing. Undue influence or fraud. Undue influence includes circumstances where the testator is coerced into making their will, and their will does not reflect their wishes. This can really be a hard challenge. Undue influence challenges usually include the need of an expert that can speak to a number of factors, including the vulnerability of the victim. Letter wills. Courts will enforce letter wills, assuming that they meet appropriate formalities, including mental capacity, knowledge, and freedom from undue influence or fraud. If you'd like to speak with us about your case, then call us at Hackard Law, 916-313-3030, to schedule your free estate dispute consultation. We'll work to get you the money you deserve. Hackard Law. Attorneys making a difference.